Hello, Ethan Vessels, lawyer in Marietta, Ohio. Today we're going to be talking about whether your oil and gas lease has expired. I've spent the last 4 years dedicating a large portion of my practice to oil and gas law, and we are now getting quite a number of calls from clients or prospective clients asking if their oil and gas lease has expired. Because we are very late into the oil and gas boom here in eastern Ohio, the Utica Shale boom, many of the leases that people signed 3, 4, and 5 years ago are starting to expire. But the question is, when does the oil and gas lease expire? Well, first we need to understand that oil and gas leases are contracts, and courts will look to the language of the oil and gas lease to determine when the contract has expired. The first major area of when an oil and gas lease expires has to do with production. Now you need to understand there are two terms to an oil and gas lease. Something called the primary term. That's the part that most people are familiar with. That's the part that says, I've signed this lease and it's 2, 3, 5, sometimes as many as 10 years. That's the period in which the lessee, the oil and gas operator, need not do anything because they are waiting and getting ready to drill for oil or gas. That's called the primary term. Once the oil and gas lessee, the operator, has drilled a well, then it moves into what we call the secondary term. Then it becomes indefinite, so long as there is production. And it has to be production in paying quantities. And what paying quantities means is profitable. Profitable to the lessee, the operator, not profitable to the landowner. That's an area for another larger discussion, which we will do a separate video on. So let's say the oil and gas lease has come to the end of its primary term, and there's been no oil or gas well drilled, nothing produced from the property. Does it expire? Well, the short answer is yes, if nothing else has occurred. But the question is, has the lessee satisfied any of the savings clauses? And what is a savings clause? A savings clause is another provision written into the lease that allows the lease to continue on even after the primary term when the oil and gas lessee has not drilled a well and is not producing oil or gas from the property. Now the key is, again, these are written contracts and the lessee has to fully satisfy the conditions of each of the savings clauses. Let me give you some examples of savings clauses. One of the common ones is the drilling operations clause. This is the clause that says if the lessee, the operator, has started drilling a well and they are in the process of drilling a well or conducting actual operations to get the lease prepared so that it can produce oil or gas, well then they don't want the lease to expire while they're still expending the funds and doing the effort to try to get oil and gas from the property. So there will be a lease clause written to allow it to continue while they are doing that. Pooling and unitization clauses. Now, we can do a whole separate video on what pooling and unitization means, but many leases have it written such that if the property that's leased, the leased premises, has part of it or all of it included in a larger drilling unit, consolidated with other leases around it, and there is a well that's been drilled and is producing before the expiration of the lease that has been consolidated, let's say your lease, if it's producing and holding the lease by production and that leased premises has been consolidated with that, well, that will perpetuate the lease that has been consolidated. Again, it's a very complicated topic. Force majeure clauses. Force majeure is the act of God, the act of war clause. This has to do with the fact that once the end of the primary term has come and the lessee cannot get oil and gas from the leased premises because of things that are beyond their control, such as wars, acts of God. They have written in there that the lease will not expire during the period of the force majeure. Now I will note that this is probably one of the most abused clauses by lessees, where they try to pack everything in there to prevent the lease from expiring. The key should be that it is truly forces beyond their control, not that they just didn't get around to it. Shut-in clauses. This is a little different. A shut-in clause is when the lessee has finished a well, it's producing, so now we're into the secondary term, and let's assume it's producing and paying quantities. And then they need to shut the well in. That's a term of art, which just means they've turned it off temporarily. Usually it's because the market for their oil or gas is not there. The prices have dropped so low that it's not profitable to continue operating the well, or they cannot get it to market. The pipeline is not there or available. Again, this is critical that you have to already have an existing producing well in order to declare the shut-in, and it must be temporary, which is set by the terms of the contract. Automatic renewal provisions. Let's say we've come toward the end of the primary term. It's a 5-year primary term. Many lessees have written into the original lease that once they get to the end of the primary term and they've not drilled, that they have the option, meaning the lessee's option, to pay additional money to the lessor that automatically extends the lease for another term of the same amount, let's say another 5 years. Usually this requires payment of the same consideration that was paid at the beginning of the lease. It doesn't have to be that way. It can be any other type of consideration. But that will basically start the lease over so that there's another term of which they have to produce oil or gas. Now, I want to re-emphasize that if a lessee wishes to extend an oil and gas lease using one of the savings clauses, they must fully satisfy the contract terms. They must meet the letter of the agreement in order to satisfy the lease. They cannot half do it or partially do it. Courts will look to make sure that the lessee did exactly what they were required to do to continue the lease. And even assuming that the lessee has technically complied with the lease, courts impose what they call the good faith standard on the lessee. Let me give you an example. The drilling operations clause. Let us assume that we have moved to the final 3 days of the landowner's lease, and the lessee, not wanting the lease to expire, goes in, drills a well that's 300 feet deep, and then leaves, and then claims that the lease continues on because they've begun drilling operations. However, the facts are that they have no bona fide intent of obtaining oil or gas from that shallow well, and all that look at the situation can see that they are simply attempting to keep the lease from expiring. Most courts would say that is not good faith operations. The same thing is often done with the pooling and unitization clause. There are valid reasons to consolidate land with other lands. However, if the lessee files something on the last day of the primary term claiming that this particular lease has been consolidated into a unit, some courts will look askance at that, saying it doesn't appear that the lessee is actively trying to get oil or gas from that particular unit, but instead is just trying to make the lease extend. And this can apply to the other savings clauses. Now, I will tell you this, whether or not an oil and gas lease has expired, whether through production or any of the savings clauses, is very complicated law. Entire volumes of law books have been written on it, and frankly, it's not a do-it-yourself operation. I would also say this is not the type of law that you can simply trust to your general practitioner. It is very complicated, time-consuming, and requires a lot of expertise. I've dedicated the better part of the last 4 years working on these very types of cases, helping landowners all over Southeast Ohio get declarations from courts that their lease truly has expired. If you're having this problem, please give me a call, 740-374-5346, or visit our website, www.fieldsdemlow.com. Thank you.